The next matter to come before the court this morning is State of Ohio versus Jovonta Delmar Moore. Both sides will have 15 minutes to present oral argument. The appellant may reserve up to 5 minutes for the rebuttal. If you are the appellant, you must reserve any time. I'm keeping track of the clock, and you can note that it's also should be on the wall over there. But if you let me know when you get started, that helps me do the pacing. The arguments are being recorded, so please introduce yourself, stating on the podium. Keep your voice up. Please don't use the names of any children or victims, as I indicate this will be posted on the court's YouTube channel. The judges have read your briefs, so ready to proceed when you are.
Thank you, Your Honor. Stephen Hardwick from the Ohio Public Defender's Office here for Mr. Moore. I'd like to reserve 3 minutes for rebuttal.
Certainly.
This is a case where we have two people who have a history of threats to each other. They both get kicked out of a house. One goes out first. And the testimony is that KP came back, one way or another, was facing Mr. Moore. Sometimes they say he was running up the steps. Sometimes they would say he was close enough to slap a gun out of his hand. But Mr. Moore, who was lawfully carrying a weapon, lawfully carrying a gun, when someone who has a history of threatening to kill him approaches him, either lunges up the stairs to him or gets close enough to him to hit the gun out of his hand, whichever way this court tends to believe that testimony, his life was in danger. Now the state says, well, the other guy didn't have a gun and he did, but you don't have to prove the other person is going to kill you. It's just serious possibility of serious bodily harm, and you can do that very easily with just your hands. No. And if you don't have any questions on that, I just want to go talk briefly about the common law argument, which I think is important here, because let's remember, the jury did not believe that Mr. Moore acted purposely. The jury acquitted him of purposeful murder. The jury did not think that he had the intent to kill.
Did the jury acquit him, or did they didn't come to a decision?
If I made a mistake on that, then I thought it was that if they didn't come to...
And then it was ultimately dismissed.
I apologize, that was my mistake. Yeah, but the jury couldn't find that he did that. And I think that's important in this case because all that's left is the felony murder. And a lot of cases that have come before courts, their person may have been convicted of both or charged with only one, but we know here that the jury wasn't going to convict him of purposeful murder. So under the plain error standard, the result would have been different because you have a verdict for felony murder that if felony murder weren't available, he would not have been able to convict him of purposeful murder. Under the common law doctrine, if you have the General Assembly, if they want to abrogate the common law, needs to do so plainly and clearly. And I gave a number of statutes in my brief where they said, we intend to abrogate the common law, we intend to abrogate the common law, we intend to abrogate the common law. They never said that here. Now the state has shown that, and I did concede in my brief, other courts have not accepted this argument, and I should have added this court as well in the Cherry case. I apologize for that, but I did explain that other courts had not accepted, other courts of appeals, but the Ohio Supreme Court has never addressed the issue yet. And I think the state actual Cordray v. Marshall is helpful in this case because it postdates this court's prior decision. And that was a case where there was an argument that that there was a statute that gave specific powers to the Attorney General. So you can be involved with this case, this case, this case, this case, this case, this case, and this case. And that the case involving Cordray v. Marshall wasn't in that list. And the Ohio Supreme Court said, no, it doesn't matter. There's a common law. There's a common law. And that the common law covers the entire list and many other things, making that entire list superfluous. But they said, no, the common law still applies and it hasn't been abrogated. That applies here as well. If the statute could, if just merely contradicting the common law was enough to express an intent to abrogate, then you wouldn't need that doctrine, because just not being consistent with the common law would be enough. I also think there's some confusion, I've seen this in the lower courts of other courts of appeals under 290103A, that says no conduct shall constitute a criminal offense unless it is defined by statute. Now, the code editor added the title abrogation of the common law. That's not in the statute. Code editor language, the titles, unless they're actually from the words passed by the General Assembly, are irrelevant. They're just guides for the reader. It's as valuable as a West Head note. In the absence of questions, I also want to come back to the lack of finding a purposeful murder. That should also color what how this court looks at the self-defense claim. It shows that the jury, at least there was not a unanimous jury that believed that my client was trying to kill or was even knowingly doing something that could kill KP. He, in the end, was protecting himself. He had a right to carry that gun. KP started a fight when he had fists and the other person had guns. And as a result, he ended up losing his life. That's tragic. If the jury didn't, and let me take one step back, under the felony murder law, under the common law argument, someone like Mr. Moore could still be convicted of felonious assault. He could still get 11 to 15 years now, or plus 3 years with the gun. It's not like you're saying people just walk away. There is still punishment in the code, and without adopting this doctrine, there are other prosecutors' offices, and I'm surprised more haven't done this, who just don't even bother with purposeful murder anymore. It's slowly being eliminated in practice, because why would, unless they have some evidentiary value in wanting to get stuff out about intent to kill, a lot of prosecutors don't even want to bother with trying to prove it, because why should they? They have an easy way out, because without the common law murder doctrine, purposeful murder is irrelevant, and this court should reverse Mr. Moore's conviction under either grounds and remand this case for a new trial. Thank you.
Thank you, counsel.
Thank you, judges. Again, I'm Rick Raley on behalf of Summit County Prosecutor Sherry Bevin Walsh and the appellee in this case, the state of Ohio. I'll start with the common law argument. The second, the fourth assignment of error, but I'm not sure if second or fourth. That assignment of error that's in the brief. And I just want to point out, this was never raised in the trial court. The trial court was never requested to dismiss this count. And I think it's a pretty big jump to think that the trial judge should have decided on the judge's own initiative, without argument or objection, to sever or dismiss that count based on a common law doctrine that has been rejected by this Court of Appeals that offers its controlling authority. In that light, I can't say that there's going to be an obvious defect in trial proceedings. I think this court should easily overrule that. To the extent that there's commentary about the rationality of the law, the forum for those arguments is the General Assembly. It's not in this criminal lawsuit before this court. For the manifest weight challenge, I think it's pretty important to indicate that the defendant had made various threats to the victim beforehand, that the victim did not have a gun on this day in particular, that the victim's mere actions of potentially going forward towards the defendant's place does not give him the right to shoot the person dead multiple times. And the jury under a manifest weight, this court under a manifest weight standard, shouldn't supplant the jury's determination on that issue. So for that, I'd ask you also to overrule that assignment of error. And if there's no questions, I'd ask you to affirm.
Thank you, counsel.
Thank you.
Just briefly, Your Honor, in terms of plain error, as I put in my brief, that we should look at plain error. Is it plain now? And if this court looks at it and says, yeah, it looks clear to us, it's plain. Now, If a big leap, this court doesn't have to think, I understand under plain error rules, I think I was clear in my brief that I raised this under plain error, it's in the assignment of error. I didn't try to hide that this wasn't raised in the trial court. And this isn't a moral judgment on the trial judge. We aren't saying that this judge was a bad judge because they didn't do this. We're saying, this is, we look at this, it's wrong, it's plain, it clearly would have made a difference, and therefore it should be, the conviction for for felony murder should be reversed. Thank you.
Thank you. Thank you both for your presentations today. The court will take the matter under advisement. We will issue a written decision which will be mailed to all parties to this appeal as well as posted on the Ohio Supreme Court website. We are now adjourned.